Good afternoon, ladies and gentlemen. I am Adam Peters, Senior Legal Counsel with ADGM Courts. Today, I'm the moderator for the second webinar of the MESEA Webinar Series 2021, jointly organised by the ADGM Arbitration Centre and the Asian International Arbitration Centre. Before we begin, please take note of the following housekeeping rules. To encourage more interaction between the attendees and the speakers, we have organised this webinar to be conducted in meeting style. Accordingly, we request all attendees to kindly mute your microphones on your respective devices. At the end of the webinar, at approximately 1 p.m. GST, we will conduct the networking session. During the networking session, we encourage you to unmute your microphones, turn on your cameras, and interact with the speakers and other attendees. During the webinar, if you have any questions, please post these in the chat box for the Q&A session at the end, and we'll get to those questions. We thank you for your attendance and cooperation. We'll shortly begin at 12 p.m. GST with the opening remarks from Linda Fitzallen. Thank you.
Adam, thank you very much. Good afternoon all. It's a pleasure to be with you this afternoon. My name is Linda Fitzallen. I'm the Registrar and Chief Executive of ADGM Courts, and in that capacity, I also look after the ADGM Arbitration Centre. It is my absolute pleasure to welcome you here today, wherever around the world you're connecting in, to the second edition of the Middle East Southeast Asia Webinar Series 2021, which is jointly organised by the Asian International Arbitration Centre, our friends, and the ADGM Arbitration Centre. This series, as many of you would know, perhaps if you were in the first part, has been developed as part of our collaborative effort with the AIAC to offer thought-provoking content focused on key industry themes for the benefit of the international dispute resolution community, and particularly those who are active here in the Middle East and also in the Southeast Asia region. Last month, we heard from a fantastic panel of speakers who discussed the Islamic arbitration, the Arbitration Rules, which are an innovative set of rules developed by the team at the AIAC for the Islamic dispute resolution community. Today's panel will be discussing third-party funding, again through a Sharia law lens, and we're extremely grateful to be joined by such a great panel of speakers. And I don't think you could probably get a better range of speakers who are able to discuss the intricacies and the complexities of third-party funding through this lens. Third-party funding in particular is something near and dear to ADGM Arbitration Centre and ADGM. We have a set of litigation funding rules. So this is a jurisdiction that recognises the activity of third-party funding. So on behalf of the team at the AIAC, as well as the ADGM Arbitration Centre, we hope that you'll find today incredibly interesting and insightful, and that you can walk away with something a little bit more nuanced about third-party funding in this particular area. So on that note, and on behalf of the AIAC and the ADGM Arbitration Centre, my sincere thanks to the speakers for their invaluable time and their insights today. We do really appreciate it. So over to you, Adam. Thank you very much. And I look forward to catching up with you all in the third series.
Great, thanks Linda. Again, I would like to welcome you all to the second webinar in our series, which focuses on Sharia compliant third-party funding aimed at Islamic investors and the Islamic finance sector. By way of introduction to today's topic, we know that the recent pandemic has placed a lot of liquidity pressure on businesses across all sectors and industries. Against that backdrop, there are increased challenges for investors to continue with their existing portfolios and to manage ongoing dispute resolution proceedings. However, along with the challenges that the pandemic has brought comes opportunity. And the focus of this webinar is to explore with our esteemed panel the increased role that Sharia compliant third-party funding may play in international arbitration. So with no further ado, I would like to introduce you to our panel members. We're very grateful to have Mr. Andrew McKenzie, partner and head of Baker McKenzie Habib Al Mullah's Arbitration, Construction and offshore litigation practice in the UAE with us. Welcome, Andrew. We have Ms. Anastasia Bodarenko, Managing Director at Vannon Capital Finance, whose remit involves, amongst other things, advising clients on third-party funding options, particularly in relation to Vannon's international arbitration portfolio. We have Mr. Dilip Masand, co-founder and CEO of Phoenix Advisors Limited, an Abu Dhabi-based firm focused on co-funding of litigation in mature and emerging markets in the GCC and surrounding areas. Welcome, Dilip. And we also have, finally, Mr. Mohammed Ridza Abdullah, Managing Partner of Mohammed Ridza & Co., which has been involved in some of Malaysia's largest and most complicated corporate and financing transactions. So as Linda mentioned, we're very fortunate to have such a talented panel with us today. That's all from me by way of introduction. It's really over to the stars of the show, which is our panel members. And to kick off the discussion, Andrew is going to deal with the topic of post-pandemic third-party funding of international arbitration for Islamic investors. And I guess that really introduces the initial question, Andrew, of what impact, if any, has the pandemic had on third-party funding for international arbitration, and what does the post-pandemic landscape look like for third-party funding?
Thank you, Adam, and welcome all. It's a pleasure to be here with you all today to discuss what is becoming an incredibly increasing topic of discussion amongst both clients and third-party funders and other players in the disputes landscape. So when the pandemic hit, obviously everyone took a step back and took stock of where they stood generally, both from a cash flow and liquidity perspective, but also from a risk perspective. As with other similar type events, although granted the pandemic is obviously almost a once in every 100 years type event, but we can draw similarities from the global financial crisis back in 2008, 2009, and indeed other recessions that have hit since then, where companies in particular, want to make sure that they don't venture out into disputes when they are uncertain of what the future landscape will look like. And that's really the same impact the pandemic had. So there was generally a feeling of everyone tightening their belts, making sure that their cash flow was not spent unnecessarily to recover funds that could potentially wait until there was more clarity with respect to how long the pandemic would last and what its net impact would be. I, like many spectators at the beginning, and indeed individuals within the disputes landscape, thought that the pandemic may, as similar recessions have in the past, cause an increase in interest within third-party litigation funding. I don't think we've yet seen that wave come. We're still obviously in the pandemic at the moment. Its impact is still very prevalent. And in actual fact, one of the outcomes of the pandemic, or one of the consequences of it, and this belt tightening approach, has been that some companies are very cash rich at the moment. They're sitting on war chests that they've compiled to try and ensure that they can get through the worst of the pandemic. Now, with global rollout of the vaccine, we've seen companies begin to loosen those belts slightly and pay out monies due both under dividends, but also to staff payments that were perhaps being withheld through global-wide people measures. But the impact on the third-party litigation funding landscape is that parties which perhaps in the past would have considered third-party litigation funding are now in a position where they may not have to, because they have stockpiled cash in order to see themselves through the pandemic. That cash has not been required in the way that they expected it might be, and therefore they've been able to redirect that cash to other avenues, including the pursuit of disputes. But those companies, those fortunate companies that are in that position, are certainly not the majority within the landscape that we're looking at the moment. So those companies who have experienced much greater liquidity pressures and problems with cash flow are turning to third-party litigation funding and are raising queries left, right, and centre with respect to that as an option and avenue to pursue the claims that they have had on their books. So what we're also seeing now is this rising interest in third-party litigation funding flowing out of the pandemic, where parties who perhaps put a pause on commencing any form of proceedings because of their concerns regarding cash flow are still in the position they were prior to the pandemic with respect to liquidity issues, and then want to pick up where they kind of left off in terms of pursuing the cases that perhaps have been sitting on the shelf over the last 2 years and are now being dusted off and being lodged. But funding is obviously crucial to getting them off the ground. So you've sort of got three major groups within the companies at the moment as a result of the pandemic. You've got the cash-rich companies that continue to fund and indeed are in a better position than they were potentially pre-pandemic because they've pulled back on budgets. You've got those parties that were in a liquidity crisis prior to the pandemic who have either survived or not survived, but if they've survived, they still require an injection of cash flow. And then you've got the parties that are most hard hit by the pandemic, particularly in the retail and hospitality space, where government measures have not been sufficient enough to keep them necessarily afloat and profitable. And they are looking for potential funding as well.
Yes, that's a really interesting analysis. And as you say, it may depend on what basket you're looking at in relation to whether third-party funding has more of a role to play. It's interesting, though, even with the cash-rich basket or entities, whether those companies or those businesses in that category look at using the available cash flow in other areas of the business to grow the business in other areas and look to third-party funding as a way to manage potential liquidity risk, financial risk, or whatever the case might be. But really, I suppose they'll be considering the best way to deploy the resources that they've got. But again, it's a watch the space in terms of how third-party funding interacts with those three baskets. That's interesting. Against that really helpful introduction, Andrew, what challenges or opportunities do you see for the expansion of Sharia compliant third-party funding in international arbitration?
So this is where you added a different dynamic to third-party litigation funding. In the past, it has caused issues in certain jurisdictions because there are issues of legal issues, legal embargoes to third-party litigation funding, allowing principles like champerty and other various legal issues that arise in certain key jurisdictions where third-party litigation funding took a while to get off the ground, chiefly because in the past, from a legal perspective, you needed to have an interest in a case before you could effectively bring it. And there was obviously this desire by the court to ensure that we didn't see a flurry of cases being lodged by non-interested parties or even being funded by non-interested parties. So that has taken a while to develop. What's curious about the landscape here in the Middle East and in the UAE specifically is that there is no legal prohibition on the use of third-party litigation funding. But where there may be an issue, and that is yet to be tested, is around the Sharia concepts that underpin our legal system here in the UAE, much more extensively in Saudi and in other Middle East jurisdictions like Qatar, Bahrain, Oman, and Egypt. And where these come into play, you have an almost two competing schools of thought. On the one hand, there is principles under the Sharia that actually would champion the use of third-party litigation funding. And that's because there are jurisprudential principles in Sharia law that is actually in the public interest to actually allow funding to be permitted to be provided to individuals. If an individual has a meritorious case, that case should not be prohibited to proceed because they lack the funding to push the case forward. So in that instance, you've got quite a strong body of law within Sharia that says that actually it's in the public interest and well-being that these cases be permitted to be brought to court, and individuals should not be disadvantaged because they lack the appropriate funding. Conversely, you've got the other school of thought, which deals with the concept of speculative or highly uncertain transactions, garara, and effectively that may apply to third-party litigation funding. You've also got this, you begin to wade into areas akin to gambling to a certain extent. You're taking a risk on a speculative, uncertain transaction, and that is certainly frowned upon and prohibited, depending on its nature under the Sharia. So with these two competing principles, a balance needs to be found. And then on the one hand, you've got that strong pillar from a public policy perspective, the public interest perspective. And I think what we've seen from some Sharia scholars when discussing this issue is that considerable weight is given to that first pillar, and that the second pillar, although important and should not be ignored and certainly not taken for granted, will essentially be considered in light of the first. concept, the benefit to the public good. But these issues need to be further teased out. They need to be discussed. Again, it depends on what jurisdiction you are in within the UAE. We might see, within the Middle East, we will see certainly a desire to push third-party litigation funding. In fact, we've already seen that within the UAE. Two of the jurisdictions, including the ADGM and the DIFC, have greenlit third litigation funding. They've issued regulations around it and how it is to be done. So they're not prohibiting it. The UAE has not done that. It's remained silent. The onshore UAE courts have remained silent with the prospect of third-party litigation funding. But what we see is on the horizon is an inevitable discussion around that topic.
Yes, it's very much a watch this space, and as you say, there are Sharia law considerations to have regard to, and we're going to pick up on that a little bit later on with some of the other speakers. But that was a great sort of overview, and I'm glad you touched on the UAE too. I was going to ask you a specific question on that, because the UAE is an interesting jurisdiction where you have the civil law and the common law side by side operating. If we can, we'll circle back on that at the end, but I'm conscious of time, and I wanted to move on to or bring Anastasia into the discussion. And Anastasia has been given the somewhat broad topic of third-party funding in OIC jurisdictions in Europe. And I wanted to touch or start with OIC jurisdictions. And just by way of introduction, I had to look this up. But OIC stands for the Organization of Islamic Cooperation. It's an alliance of 56 countries in which Islam plays a significant role. Together, those countries have a total population of 1.86 billion people, or 24% of the world's population. So we're talking about a significant market in itself. And we're very fortunate to have you, Anastasia, because you can give us your insights from a funder's perspective. And with that in mind, what considerations might arise when a funder is assessing whether to enter into a third-party funding arrangement in an OIC jurisdiction?
Thank you, Adam, and thank you very much for the invitation to speak. I'm delighted to be here. So to answer your question, touching a little bit on what Andrew said, to the extent that there are no formal prohibitions, such as for entering into a third-party funding arrangement, such as chambering and maintenance, when assessing whether or not to enter into a third-party funding arrangement, we will adopt a holistic review of the opportunity, as we would with any other opportunity. As you mentioned, the OIC jurisdictions cover a vast market, very different countries and sovereigns in and of itself, in and of themselves. So, on the one hand, you have Kazakhstan, on the other hand, you have the UAE. So it's quite a spectrum. What we will assess, we will review the opportunity like we would any opportunity. We will first look at the financial aspects of the opportunity that we're being presented with. And so this includes looking at quantum of the claim. So how much are you seeing, how much is being sought, at the budget and the ratio between the two. And what we're looking for is a 1-to-10 ratio between budget and quantum. And this is to ensure that if and when the claimant is awarded less than it claims, which is more often the case than not, client will not see the law firm fully paid if there's a contingency element, the funder walking away with a lion's share of the damages. So, this ratio ensures that this is something the funder has already taken into account in its assessment. When evaluating, for the purposes of our analysis, we take a very conservative view of quantum. So, for example, if we're looking at an expropriation of a greenfield project, for the purposes of our analysis, the quantum that we will retain is the documented sunk costs. If we're looking at the expropriation, let's say, of an ongoing concern, we will look at quantum based on documented and historical cash flows for a claim that's neither, overly speculative nor overly optimistic. Once we gain comfort on the financial aspects and we're comfortable that the financial aspects of the opportunity fit within our funding criteria, we then move on to enforcement. And what we're looking for is a clear path to enforceability of an eventually favorable, successful award. And we're also looking at, what potential hurdles there can be to enforcement, what strategy there is to mitigate the risk of these hurdles, what will be the likely timing and extent of recovery. So for that, we will look at a respondent's history of complying with adverse awards. We will look at the respondent's ability and willingness to pay. We will also look at specific enforcement targets. Should payment not come voluntarily, and also we will consider obviously set-aside risk of deceit. And that's where the national legal landscape and legal regime comes into play as well. And then we move on to jurisdiction and merits. And so what we're looking for is comfort that the given opportunity presents at least a 60% chance of success, both on jurisdiction and on the merits. And we're obviously looking to for the case to be governed by a stable, reputable, arbitration-friendly governing law, by same for the seat of the arbitration, and also to work with, conducted under the auspices of a reputable arbitral institution.
That's great to get your overview on that, Anastasia. Just sticking with the OIC for a moment, as I said, the common denominator is that Islam plays a significant role in those jurisdictions, and I think it's a nice segue into the next question that I have for you, which is Sharia law in itself an impediment to third-party funding? And I've put that question to you because you co-wrote a very good article on this point, which I found very interesting, and I thought our audience might also benefit from an overview of that.
Thank you. So again, Andrew touched upon this, and he put it very, very well. As far as I'm aware, there are no formal contradictions in Sharia law against third-party funding, in that under Sharia law principles, there are no concerns with an unrelated party having an economic interest in a case. And so to conduct the analysis, it's helpful to start and to recall what third-party funding is. And essentially, it's a simple financing arrangement whereby a funder agrees to pay a party's legal fees and costs in accordance with an agreed budget after having assessed the merits of the case, and all this on a non-recourse basis. So what this means is that a funder will only recover its investment and be entitled to a return on its investment if the claim is successful and if monies are recovered. So the funder is only paid from the recoveries arising from the given dispute. If the claim is unsuccessful, the client has nothing to pay and the funder loses its investment. The exact terms of the financing agreement are carefully negotiated and set out in great detail in a funding agreement, which is entered into between the client's lawyers, and the funder. And the funding terms are also tailored to take into account the specifics of a given case. So for example, there will be discounts for early settlements, or terms are usually calculated either as a multiple of the investment or a percentage of the recoveries, or a combination of the two. So for example, as the quantum increases, the percentage of recoveries that will be for the funder's share of the percentage of the damages will decrease. So we're not going to be asking for the same percentage for a $5 million recovery as we are for a $50 billion recovery, right? And so what's also very important is to note that third-party funding is not a loan or another type of non-recourse financing. So in view of this definition, third-party funding in and of itself, in its most basic form, is not contrary to or in violation of Sharia law. As you previously heard, there are three features of Sharia law which could be a cause for contention in the context of third-party funding. The first is the prohibition of interest. However, because third-party funding is not a loan, and what is awarded to a third-party funder, or what is ultimately paid to a third-party funder, is not interest, but it's a share of the proceeds in the event of a successful outcome, in accordance with a ratio which has been negotiated and pre-agreed with the client. There is no tension there once you really break it down. Then you have the prohibition of any transaction that involves uncertainty and speculation. Again, this is not an issue when it comes to third-party funding conducted by a professional funder, because the terms of the funding agreement, including the amount, the timing of the payment, are all negotiated by sophisticated parties, supported by sophisticated counsel, and are set out in precise detail. So contracting parties therefore know the exact contractual scope. And the third aspect is the prohibition of gambling. So it's equally an opposite when it comes to the funding of a dispute by a serious and professional third-party funder, because professional funders make exceedingly careful and well-researched investment decisions. We do not fund spurious claims. We only fund claims we truly believe to be meritorious. So for example, at Vanen, our due diligence process is multi-level. We have a multi-level due diligence process. So the first level is that there's an internal review conducted by counsel with experience in that specific type of dispute. That's what we're talking about. Insolvency disputes in Australia, that will be handled by the Australian team with somebody who has specific expertise in that. We're talking about international arbitration, that will be handled, that will be reviewed internally by somebody who has several years of experience as counsel in private practice in international arbitration. And then we have, if internally we believe that case fits our funding criteria that I discussed earlier, then we go to the second level review. And in the second level review, we engage external counsel, again, suited specifically for the given type of case that we are looking at. So let's say it's a mining arbitration. We will go and find a specialist in mining arbitration. We'll also engage external quantum expert and an external industry expert where that's necessary. All of this, they will all be consulted to review the case. So again, as you see, this is not, gamblers wouldn't last very long in this industry. And so, the concern with Sharia, with respect to Sharia law, stems from the general unfamiliarity with the system and the fact that it's an uncodified body of law and that its interpretation and application varies. And, so it's the uncertainty related to the consequences of this potential interpretation and application to a given situation. However, again, professional funders are able to navigate these territories and are able to ensure that the funding agreement is tailored to take into account these various aspects. And sophisticated funders will be aware of how Sharia law affects the funding agreement, and they will be able to collaborate both with the funded party and with the counsel and with their own specialists to ensure that the funding agreement doesn't fall foul of Sharia law principles.
That's a great analysis, and if you throw in Andrew's public interest element
Exactly.
in his part as well, which sort of really underpins Sharia.
Exactly.
The takeaway that I got from this was that there's at least a respectable argument that Sharia is less of an impediment to third-party funding than the common law doctrine of championship and maintenance, and that's an interesting soundbite, and it certainly is something that I've learned throughout the course of preparing for this presentation and obviously today as well. I wanted to ask you about third-party funding trends in Europe, but I'm conscious of the time. But please hold on to that thought because we might circle back in the Q&A session if we have the opportunity. I want to bring Dilip in on the discussion now, and Dilip's kindly offered to speak to us about possibilities for third-party funders to invest in a new asset class aimed at Islamic investors in the Islamic finance sector. Now, Dilip, given that third-party funding has been described as a mainstream asset class or an alternative asset class in jurisdictions such as the UK, US, and Australia, what lessons do you think the emerging markets can glean from some of the more established markets when it comes to third-party funding?
Thank you, Adam, for that question. And let me also thank the ADGM Arbitration Centre and AIAC for allowing me to be a part of this discussion. It's always great to be part of these innovative discussions in these parts of the world. So to answer your question, if you look at these, the three jurisdictions you talked about, I mean, one, we can see that litigation funding is clearly an established financial asset class or a product, just like private equity or venture capital. The fact is that in each of those jurisdictions, we have publicly traded litigation funds. So that means there's a growing degree of transparency in the industry as to how are these assets valued, because you've got to look at, you know, what is this trading at, as well as a good deal of corporate governance coming into place. So I think this also goes to issues of speculative ventures. This is not a speculative venture. I think what emerging markets can learn too is also looking at some of the emerging markets that have already allowed the entry of third-party funding. So if we look at Singapore, Hong Kong, and the UAE, both the ADGM and the DIFC, you know, we've got, I would call it from a regulatory standpoint, light touch regulation. This is not an industry that needs to be heavily regulated because, to Anastasia's point, you have a lot of self-governing professionals in this industry who are risk averse per se. But, you know, still regulations or rules that talk about conflict of interest between lawyers, clients, and the funder, the decision-making process remaining within the client's hand. And I think, you know, as you see in some jurisdictions, perhaps some requirement of minimum presence in that jurisdiction or even minimum capitalization, et cetera. So, you know, we can already see a trend in some of the emerging markets recognizing we need this, and let's set up an entry avenue for this. And then I think, look, from what we're seeing in the US, Australia, the UK, there's clearly an economic benefit to the entire ecosystem. As Andrew was saying, you are seeing corporations that are a bit cash. I see the corporations that are a little bit cash strapped, where the CFO might be talking to the general counsel about how can we get some balance sheet relief here. You are seeing real estate projects that are held up. There are contractor claims. So, you know, it's another economic engine within the local economy. It's good for corporates. It's good for law firms as well. That's ultimately a business someone has to run. How much risk can they take? Maybe a funder can come in and work out an arrangement with a law firm where they can look at the success component of their portfolio of claims or their clients and use that as some form of a collateral and enter into a financing arrangement. And I think the last thing really is it does create a lot of efficiency in dispute resolution. You know, law firms are held a little more accountable as to the fee side. And in emerging markets, I think it also helps accelerate foreign direct investment. We are talking about arbitration. Most joint ventures that you see are foreign investments into emerging markets have arbitration as dispute resolution. You're seeing new arbitration and conciliation acts that have clauses allowing third-party funding. So a funder is an investor in that foreign jurisdiction as well. And I do think that it opens the door to foreign direct investment on a larger scale and more transparency and efficiency in the dispute resolution process of those kind of investments.
Yeah, that's certainly true. A question that I wanted to ask you under this heading or under this guise, which I'll save for the Q&A at the end, but perhaps you can just think about that in the interim, is there such a thing as first mover advantage when it comes to emerging markets and third-party funding? So we might pick that up at the end under Q&A. But the next question I wanted to explore with you is to what extent do you think that third-party funding products will need to be tailored in order to be suitable or at least more attractive for Islamic investors and the Islamic finance sector?
You know, I think Anastasia and Andrew laid a lot of groundwork for me to answer this question, so they made my job a little easier. But truthfully, I don't think it needs a lot of tailoring. I mean, look, we already have established Sharia compliant real estate funds. We have the Dow Jones Islamic Index. So in a way, we have general guidelines as to certain industries perhaps funders should not touch or might have to be a little more wary of, such as something in the food and beverage where alcohol it may be served in an establishment. Personally, I think from a principle standpoint, I wouldn't want us to get involved in family law matters. So we do have certain guidelines, but I think in terms of structures, I think actually Sharia law lends itself quite well to third-party funding, because you have a recognition of partnership in Islamic business transactions. And you have two modalities that are really well established: the mudaraba structure. And if you apply that to third-party funding, you have a situation where the funder provides capital to fund the claim. The client in partnership or in strategic partnership with their law firm is making the decision. And then the distribution of the recovery is according to very set parameters. So essentially that is a structured partnership where everyone has a role and everyone has some sweat equity in this. In the musharaka, which is the other modality, you often have both parties in that partnership providing capital. And in third-party funding, oftentimes there is a client who is willing to put some capital in, but not all of the capital in. And again, that's a risk sharing, and you also have the reward sharing in proportion to that investment. So I think if you look at those two existing modalities of partnership, taking a third-party funding arrangement and having it fall within these is not going to be a lot of work. I think what does get interesting as this evolves, Adam, is situations where, whether it's a portfolio of claims, where oftentimes those are moved into a special purpose vehicle, that can be considered a contribution by the claimant. And then a funder will have, a funding pool dedicated to the pursuit of those claims in that portfolio. I personally would love to put that into the Islamic finance box and get some opinions on that and see if we can make that structure work as well.
Yeah. I think the key takeaway from that for me is that there are Islamic financial products out there that are well suited already, or compatible at least with third-party funding arrangements. And I don't want to say too much more about that because our last speaker, Mohammed, is going to talk to us further on potential structures that may be compatible in the context of Sharia compliant third-party funding. We have 2 minutes left, Dilip, and in that 2 minutes, can you consider the question, when you consider, or when Phoenix considers funding or co-funding a case where Sharia may or will become relevant, to what extent does that impact on your risk assessment as a funder? So just some highlights.
Sure. I think, it would impact the extent that you look at any unique bespoke opportunity. For instance, for us, Anastasia said it, but look, there are 4 pillars of funding in the decision-making: merits, jurisdiction, quantum, collectability. So if you look at the merits, right, you're going to have to look under which body of law is this agreement governed, or, is this case going to be adjudicated? So if it's Sharia law, we're going to have to look at, is it a meritorious claim under Sharia law? If you look at jurisdiction, again, civil, common, Sharia, how do these interplay? That is, okay, if it's in a Sharia jurisdiction, it's a factor, but it's not the overriding factor. It's just like taking a construction claim into consideration to some extent as well. In terms of quantum, I think it gets interesting in an enforcement context. If we have an award with interest, now we may have to adjust that quantum if we go to enforce in a jurisdiction where Sharia law is the law of the land and public policy concerns may come into play. And I think, that brings us into the 4th one, which is enforcement. It's simply a factor. We might look at a foreign award that is in a common law jurisdiction, bring that into a Sharia law jurisdiction. And again, public policy may come into effect in the enforcement. So it's not going to be the sole determinative factor, but it is something that we'll have to look at in each one of these 4, I would say the 4 metrics that we generally look at.
That's a really helpful overview. Thanks, Dilip. We'd love to explore this further, but time is our enemy today. And I want to bring in Mohammed Ridza into the discussion, who's going to speak to us on third-party funding in Malaysia and Asia, and this is really a great way to conclude this webinar, because it ties in so well with our overarching theme of the webinar. So, Ridza, I know you wanted to provide us with an overview of third-party funding in Asia with a particular focus on Malaysia. And Malaysia in particular has had an interesting journey with third-party funding in terms of what it's gone through over the last couple of years, where it's at, and also would be grateful for your insights on what you think the future for third-party funding in Malaysia is. So under that introduction, we'd be very grateful to hear your thoughts on third-party funding in Asia generally, but also with a focus particularly on Malaysia.
Thank you, Adam. Thank you, ADGM, for inviting me with my fellow learned colleagues. The advantage of being the last speaker is, I suppose, most of it is make my job much easier. It's been covered by my other learned colleagues on the subject matter. But maybe specifically on Malaysia and Asia, I think in Asia, I think the two named jurisdictions that I can think of is Singapore and Hong Kong. They've been fairly advanced in terms of third-party funding. In fact, I think these two jurisdictions have been competing with each other. In fact, for that matter, Singapore law now, in fact, permits third-party funding in international arbitration. And in 2019, they've also included domestic arbitration. Hong Kong has gone one step. They've, in fact, enacted the arbitration and mediation legislation, which permits third-party funding in arbitration and also mediation as well in Hong Kong. Malaysia is a bit of a unique position because the doctrine of champerty has not been abolished in Malaysia. That's the legal position. When it comes to cases, there've not been a particular Malaysian case which actually addresses litigation funding or whether it can affect an arbitration award. There's only been two cases that has been discussed in this subject matter. The one case was back in 2014. It's in relation to Miasat Broadcast Network. Now, in that case, the court, it was a high court, it considered third-party funding in a domestic arbitration, but the subject matter of that case was more on security of force. So the court didn't actually go one step further to consider whether third-party funding was champertous or not. And then that particular same case was actually referred to in another Malaysian case involving an oil and gas project, Sabah Shell. Even that particular case, it was concerning an injunction to restrain a performance bond. So same thing again, unfortunately, the court did not consider third-party funding. Because the position in Malaysia is that one way of doing it is actually to use a different governing law. There has been, I think I know of, unreported third-party funding where they use a different governing law to actually for third-party funding in Malaysia. And I'll explain later when it comes to the Sharia part. That's the interesting part, because Sharia part has a different mechanism because Malaysia is quite advanced when it comes to Islamic finance.
Yes, and for the audience's benefit, can you just tell us a little bit about the recent journey with the proposal to introduce third-party funding into the Malaysian Arbitration Act? There's obviously a will to do that amongst the dispute resolution community. It fell over at the final hurdle, but can you just tell us a little bit more about that?
Yeah, you see, the Arbitration Act, the Malaysian Arbitration Act in 2005, it was further amended in 2018. And there was a proposal to actually introduce third-party funding for arbitration, but unfortunately, the proposal fell through. So if it had been included, then it would have opened a different path. But my view is very simple. There are many ways of doing it. While waiting for the community or the legal community to look into it at another opportunity, We can still look at third-party funding in Malaysia, but again, like I said, one way is using a different governing law with respect to that subject.
Okay. That's a really useful overview for us. The other aspect of your discussion today, which I think would help to tie everything together, because we've heard quite a bit from our other speakers, and we're very grateful for that, on the Sharia aspect of third-party funding, the Sharia principles or legal considerations that may arise. And I know that you wanted to address us on Sharia aspects of third-party funding and also relevant structures, including Sharia compliance. So we'd be very grateful for your thoughts on that, Reza.
Maybe I can share you my experience, not just in Malaysia, but globally as well. In my aspect, in managing Sharia aspects, not just in Malaysia, but in Europe, in other jurisdictions, Australia, Singapore, UK as well. The beauty part about Sharia, third-party funding, I think my Anastasia mentioned it, and then I think Andrew and also Dilip mentioned it very correctly, to say that there should not be any impediment when it comes to Sharia third-party funding. Because the beauty about Sharia is that in Malaysia, where we are unique is that our system of jurisdiction is a hybrid jurisdiction, whereby we actually recognize Sharia structures in a civil court. So I don't think there's any jurisdiction who actually do that. We don't actually have a separate court. We have a Sharia court, but under our federal constitution, the Sharia court is only with respect to personal property matters like divorce and bara'i. But when it comes to banking or funding, for that matter, the civil court just actually recognizes Sharia compliant aspects. And of course, when it comes to funding, most of it is in relation to banking, the financial institutions. But using that, our central bank has actually got rules and regulations, and mudarabah and musyarakah is actually the best Islamic financing structure, if you ask me, universally, because that is one part where it is universally accepted in any madhab, for that matter. The problem with Sharia investing, in my experience handling in other jurisdictions, I have got to adhere to the Sharia Council of that particular country. All right. So in most structures, I don't have a problem using a mudarabah and musyarakah concept, because mudarabah and musyarakah is actually the pristine Islamic finance. If you look at the structure, and if you look in terms of the Islamic jurisprudence aspect of Sharia, and we have done actually several mudarabah and musyarakah, although it's not related to third-party funding for litigation, but it's the same principle applies in any Sharia project where we do mudarabah and musyarakah. And the beauty about doing mudarabah and musyarakah is that you don't actually need a specific SPV to do it. You can actually, create, an unincorporated mudarabah and musyarakah. The only thing that you have to be careful is that when you do Sharia third-party funding, you must also ensure that the subject matter is Sharia compliant. So let's say, for example, you can't do Sharia third-party funding if there is a claim in relation to a non-Sharia subject matter. Like for example, you want to claim for maybe a gambling or casino project, for example. But even that also, you need to do a proper due diligence in the subject matter, because there are some real estate projects. It may look Sharia compliant, but you must also look in terms of what aspects does the real estate property. For example, if it's a mall, for example, there is one project that we did where we acted for the Kuwaitis, where it was a huge project, but there was a mall. So we did Sharia funding with respect to that project, but we had to exit once the mall is ready and inject it into a real estate trust, because the mall had some aspects of non-Sharia like cinema and some other aspects of it. That's the aspect of the Sharia funding, the intricacies of the way. And the beauty part is when it is Sharia compliant in terms of third-party funding, you can do it in Malaysia easily, because we recognize, the courts recognize the mudarabah and musyarakah concept.
And what scope do you see for the role of third-party funding in the Islamic finance sector, projecting forward?
Okay, this is actually good, because it is actually, for me, it's a new asset class. Because as you know, injustice. When Sharia, in 1960s, when they first started, of course, Sharia has in the last 1,400 years, but then there was a gap, and then they restarted it again. And they were trying to, shall I say, do a catch up with the conventional funding. But when this is an additional asset class, you could actually have many projects or products now in terms of getting even global investors. And then now you're talking about Sharia ESG as well. That's another additional part. But as what mentioned earlier before, if you're talking about, gharar or, but again, that can easily be addressed, because like what I think Anastasia mentioned correctly, when you actually don't simply go into any particular project, you actually engage counsel, to give you a legal advice, a legal opinion in terms of, how the project is. And in terms of maslahah, we have this concept of maslahah under Sharia, for public interest policy, where you justify the Sharia part. So with this particular asset class, you can actually have a lot of third-party funders, not just Malaysia, not just it can be Sharia third-party, and because a lot of investors nowadays, they look at ethical funding. So it doesn't matter, because and most Sharia funding is actually consistent with ethical funding. So you can actually create a bigger asset class for third-party funding in Sharia.
Yep. And I think, just circling back to some of the earlier discussion, we know that third-party funding in some of the more established markets, it's a proven asset class, and that's something that investors can have confidence in relation to emerging markets. It's been tried and proven as an investment vehicle.
Yes, correct.
And we've seen the incredible growth in some of these markets, including the UK, Australia, and the US, and so forth. So again, emerging markets, there's the real potential for growth in this area. Right. But it's a real watch this space. But it's been fascinating to get your insights in relation to the Malaysian journey, in relation to the Sharia law issues and considerations at play. And as I said, I think after Anastasia's presentation, for me, one of the takeaways from this is really just how compatible the whole third-party funding concept is with Sharia, and it's not a huge paradigm shift to go from one to the other. In fact, the two can coexist extremely well. That's all that we have in relation to the formal presentation, because we have a segment dealing with Q&A for the next 6 or 7 minutes or so, and I've just been mindful of trying to monitor the Q&A box. We did have a question which was geared towards India, and it was not so much a question as more a request for insights from our panel members on what the scope for third-party funding in India might look like. And by way of introduction, the comment is that the legal position for third-party funding in India is quite clear, in that it is permitted by statute, but many corporates are not aware of its existence, maybe how it operates, its use and viability and utility. So for the panel members, what do you see for India in relation to third-party funding going forward? I'd be interested to get your views and insights on that.
Adam, if I could jump in, being one of the founders of the Indian Association of Litigation. Look,
sure.
India is very much on the funding world's radar right now. I mean, if you look at it really from scale, the two biggest common law jurisdictions in the world are the United States and India, right? That being said, look, there are some challenges with India, and I'll tell you the way the funding community globally looks at it, the way I see it. The majority of funders right now will look for outward bound disputes, particularly arbitration claims coming out of India, because you can be a little more comfortable or have more experience with arbitration in Singapore and London or elsewhere involving an Indian party. So you've got a bit of a schism in the funding world where a lot of the funders are saying very interesting, but I want to look at the outward bound arbitration claims first or commercial claims. But what you have domestically is a growing subset of domestic funders. There are two domestic funders we know of in India right now. We're sort of mentoring them to some extent as well. It's a very large market with a tremendous, I think, tail to it. But there are some structural issues in India for a foreign investor coming in. Literally, it is, what is the structure of my investment in India? What are the tax consequences in India? There are currency issues that one has to take into account. So the established funding industry is very interested in India, looking towards things like the new Arbitration and Conciliation Act, which has shortened the time frame for domestic arbitration in India. But put it this way, there's a tremendous amount of interest, a tremendous amount of opportunity, but I think some work to be done on the domestic side to make the majority of the funding community feel comfortable funding a domestic matter in India. And that's my take on it. Happy to love to hear others.
I would very much agree with that perspective. I mean, from what we're seeing, outbound work out of India, particularly on the international arbitration front, there is definitely a desire and an increased desire to hear more about third-party litigation funding. The domestic market is obviously heavily regulated. International firms are not allowed to play in that particular space, and therefore it's difficult to really get a sense from the market itself as to how that is unfolding. But I completely agree with what Dilip said. That's generally the sense we get from when we do speak to our local counsel on the ground.
Yeah, so huge markets, huge opportunities, but there's challenges. There's one final point that I wanted to pick up on with Anastasia in relation to trends and developments in Europe, and we've got 2 minutes left. I was wondering if you could kindly provide us with what you've seen based out of Paris, working for Vanham, what you've seen in Europe over the course of the last 18 months, 2 years, and then maybe a little predictor for the future.
Yeah, so I mean, what we're seeing is obviously the continuation of the increased momentum and popularity of third-party funding, especially given the liquidity crisis, which Andrew talked about earlier. What we're seeing also is that we're seeing greater interest from corporate, well-capitalized corporates who are interested in what we call corporate disputes portfolio funding, where essentially it enables them to pull forward cash flows from future dispute recoveries. And we are paid from the proceeds of all of the cases. And so successful cases subsidize unsuccessful ones, and we're able to hedge our risk. It's an interesting product where there's been a lot of talk about it and increased interest from well-capitalized corporates. Also, well-capitalized institutions are starting to see third-party funding as one of the tools available in their suite of risk management options. And so even if they are cash rich, they have internalized the benefits of third-party funding, and the fact that used in the correct way, third-party funding can enable them to actually see their claims as assets rather than liabilities. And it also enables them to take the cash that they may be sitting on and deploy it into more core aspects of the business, which will generate more profit, higher profit on the capital employed. And we're also seeing increased interest from law firms as well, who are continuing to explore the use of third-party funding as a way to offer both optimal rates to their clients, and also as a way to shift the risk of any contingency fee agreement they may be willing to enter into onto the funder.
Right. Thank you. Thanks very much for that overview. And I know it's sometimes difficult to provide an overview in a couple of minutes, but we really appreciate your insights there. On that note, I'd just like to thank our panel members who have given their time. It's been an incredibly informative discussion. I've learned a lot. We really appreciate your insights coming from different perspectives and different jurisdictions, and also from different practices. So thank you. And as I say, we're very appreciative of the time and the knowledge that you've given to us all today. Before we move on to the networking session, which is to take place shortly, I I just wanted to remind you of the third webinar in this series, which will take place on the 14th of July 2021 on construction and infrastructure dispute resolution in MESEA. So there we have it there. That's the invitation, the flyer. So please put that in your diaries. We'd love for you to join us on the 14th of July. On that note, again, I'd like to thank the panel members, I'd like to thank the audience for giving us your time as well. Don't go anywhere because you'll be allocated to a breakout room where you can we can continue the discussion with the speakers. If you've got any questions, we can deal with them in the breakout sessions. So thank you. That concludes the formal part of this webinar series. Thank you.